I met with a client the other day. She came in to talk after CYF had already gotten involved in her life, and she felt so pressured when they came to her house to sign a safety plan, to talk to them about her kids and the allegations. And she just felt frustrated because she didn't understand.
That happens a lot, and they make it seem like the safety plan is voluntary, but the reality of the situation is if they don't sign the safety plan, it's possible that children and youth could try to file something with the court to, one, take their kids into their custody, and two, become involved with the court, what's called dependency, and make them do services or other things through the court. And it becomes very extensive. There's 3-month permanency review hearings, and children and youth often does not make them aware of that when they are at their house and telling them they have to do certain things.
And they don't always make them aware of what the allegations are or the nature of the allegations. So there could be a general protective services investigation, which doesn't necessarily involve child abuse, or there could be a child protective services investigation that does involve child abuse, but they're very different and they affect your child abuse clearances differently. And they're based off the allegations, but a lot of times they won't even tell people that.
And they're supposed to be put on notice with a letter that says that there has been a referral received about the child, and make them aware that they're the parent of the child that's the subject of the report or the alleged perpetrator. And then they should receive a separate letter to inform them of the outcome of the investigation, whether it's unfounded, indicated, founded, or not validated or validated for services, and recommend services. But again, this is often not communicated to the people who are being talked to by children and youth.
Right. And the unfortunate thing is a lot of those founded or unfounded decisions are made by CYF behind closed doors without a person's ability to interject themselves. The only time that they get to do that is if after they receive the decision from children and youth, they file an appeal, which we absolutely can do, and we can have a hearing and we can challenge their evidence. But it seems like people don't necessarily understand their rights as it relates to children and youth and what their options are, particularly when grandparents are involved in cases and want to try and help be a resource.
Yeah, and they do have 90 days from the date of the letter making them aware of the indicated finding to appeal. But again, if that time frame has passed before they appeal, then they lose that chance. But with respect to grandparents, they have often been excluded or not necessarily involved or had the right to be involved in specifically dependency cases. But recently there's been a new act, Act 48, passed that gives kinship care resources, so grandparents or other extended family members who could provide care for these children instead of being placed in foster care or with children and youth. It gives them the right to receive notice of hearings and be heard as to their qualifications to be a kinship care resource. So if they're made aware of that, they would know that they have a little bit more of an option to try to make themselves known to the court so that the court can possibly have the children with a family member as opposed to strangers or foster care.
The children and youth system is just very complicated, and people feel like they have to do certain things and things have to go a certain way. But it's really important that people understand what their options are and what they can do to protect themselves and their family once CYF becomes involved.
I agree.